Ma'am, shall we start now, ma'am?
Okay, we can start.
Yes, ma'am. Good evening, my dear respected professors, faculty members, participants from various institutions for the day 2 6-day faculty development program sponsored by AICTE-ATAL on fostering intellectual property rights strategies for advancing healthcare and medical technology innovations. So we are in day 2, session 3. The first session will be handled by Dr. Gauri Gargate from Rajiv Gandhi School of Intellectual Property Law, IIT Kharagpur. And session 4 will be handled by Dr. Maithili Saravanan from North Carolina University, USA. So coming to the first session, the session will be on the topic on demonstration on patent search strategies. Professor Gauri Gargate has 25 years of experience as a teacher, researcher, consultant, patent associate, and research scientist. Her educational background is she obtained her PhD in IP management from IIT Bombay, LLM in IPR from University of Mumbai. Madam is a gold medalist from University of Mumbai, and she is also a registered patent agent, TIFAC scholar. She has been recognized as WIPF Powerful Woman in IP India 2021 and Successful TIFAC Scientist 2021. She has published her research work in reputed international journals. She has presented her research work in various international conferences organized at various places across the world, which includes USA, Canada, France, and Dubai, and many more. She worked as a guest editor for a special issue published by InterScience MIPS 2014. She has organized several national and international conferences on the topic intellectual property rights. She is also a co-editor for an international conference MIPS 2014, and this will be published. This has published by the Elsewhere publishers. And Madam has developed 5 Swayam courses, which is available online free of cost and benefited almost 1 lakh learners. She has been a resource person in various programs such as various FDPs, conferences, seminars, and delivered keynote addresses on various IP topics. As a patent associate, she has handled a number of projects such as patent filing, prosecution, IP auditing, patent mining, patent searching and drafting, oppositions, IP valuation, competitive intelligence, technology transfers, patentability search reports, and so on. Madam has developed various tools and models for IP management, and she also helps organizations in their IP portfolio management. She provides consultancy to private organizations in various IP domains and also organizes IP workshops, IP clinics to help inventors for identification of their inventions for patent filing, along with its further management and commercialization. Madam is also a member of various advisory committees of several institutions. She has conducted several consultancy and research projects for government and non-government organizations. Once again, I welcome Professor Gauri Gargate ma'am for delivering this session 3 on the second day. I welcome you, ma'am.
Good evening, all. Am I audible?
Yes, ma'am, you are audible.
Yes, ma'am.
Thank you for the nice introduction, and thank you for this opportunity to interact with the learned faculty and the students if they are there attending this particular now FDP program. Okay, So should we, I guess I should share the PPT so that hold is it visible?
Yes,
Is it
ma'am.
visible? Yeah. Okay. 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 So for next, I guess we have 1.5 hours. Okay. So what we will do in that, we will try to walk through uh, this particular strategies for patent searching. But before that, I assume that you know the basics of intellectual property. So just a small exercise we will do, and then we will go into the intricacies of a patent searching. So everybody ready for that? I'm always a teacher, so I will try to start with some quizzes or something like that, as all of us we do. So what I will do, I'm sharing with you some. See now here, we will talk about knowledge economy and all that. One few questions we will just go through, and then we will go into the details. I'm just posted here one question. I just try to understand how exactly you will analyze this particular thing. Are you able to see that thing, everybody? Please.
Yes, ma'am.
Yeah. You
Yes,
just
ma'am.
go through and try to answer this question. Yes, please. Can you just write down in chat box, or can you please write down? You can unmute, and you can, if it is allowed, you can just say that what it is. Chat box. Let me see if it is opening. Hmm. Ah, yes. Okay. So I can see the messages here very clearly. Can you just write down the answer here quickly so that we can move further? Yes, you will get patent. Okay, that is one answer. Anybody have any other answer? He can get patent. Kushbu, Dr. Kushbu is saying that thing. Nirupama is saying that yes, he will get the patent. Yes, any other answer? No. Dr. Bhuvneshwar is saying that he will not get the. Professor Resh cannot get a patent in India for his invention because he had already published his work in renowned journal in 2022. Okay, this is the answer given by Krishnavin is saying no. Yes, yes, good, good, thank you. So we have a mixed reply. Um Pisheshwara Rao, right? If I'm correctly pronouncing,
Yes,
Kolu
ma'am, Dr.
Pisheshwara Rao, right?
Picheshwar,
Yeah,
ma'am.
yeah, right, right. So thank you for giving the explanation also for what, why he will not get the patent. But you just said that he cannot get patent in India. So I have a next question: whether he will get patent in some other country?
No, as per my knowledge, it is no, ma'am.
No. Okay. So once novelty aspect is lost, nobody can get patent in anywhere, right? So the
Yes.
answer for the, yeah, thank you for responding. Thank you so much. So the answer for this is like a yes, he cannot get the patent for this particular thing because he has published it. So this is no, he will not get the patent. Okay, I have another question. If anybody have any question, anytime you can stop me and we can discuss and then we can move further. Here is another question.
Ma'am, please explain why he didn't get the patent.
Oh, okay,
What's
okay,
the
okay, fine,
reason?
fine. Yeah. So see, when we are talking about patent, and therefore I thought, okay, I would just want to know when we are going for the patent searching, we are going at a next level. So before that, we should know what exactly patent is, and therefore I have given this type of question to understand whether we are on the same page or not. So when we are talking about a patent, there are three criteria. Okay, patent is given two, three important things we have to remember always with a patent. First, we should remember patent is like given to inventions or innovations. Okay, there is a difference in invention and innovation, but you just remember that invention and innovations that will get the patent, qualifying for patent. Now, what are the criteria for patent? For patent, there are three criteria: novelty, non-obviousness, and then there is a industrial applicability. Industrial applicability, we can easily understand whatever gadget or whatever process I'm developing, whether it is has a value in the market. So that is the first thing. That is, we have to check that thing. That is the industrial applicability. Second thing, I have said non-obviousness. So suppose we all are mechanical engineers and we develop the device, then my fellow colleague should not feel, oh, it is so simple, I would have also prepared that thing or developed that thing. If that kind of a reaction is there, it's simple litmus test I am just sharing, uh, then it is not qualifying the test of a non-obviousness. It should be like that, oh, I have never thought about this kind of a solution will be there. If this kind of a reaction is there, then it is a non-obviousness. Simple, we can say the litmus test you can use like this. Then there are other criteria are there further, but basic we should know this particularly. And the third one is a novelty aspect. So what is a novelty aspect? Novelty aspect for patent is it should be first time in the world. In the world, nobody should have explored that, published that. It should not be available in public knowledge. It should not be like published in newspapers, articles. So anywhere it should not be a traditional knowledge, right? So it should not be anywhere. First time it should be available to the public in the world. So that is a novelty aspect. So when now here Professor Suresh is like he has already published that thing. So once he has published, it has been accessed by so many people, right? Once it is like accessed by anybody, then it lost the novelty aspect. And as that novelty aspect is lost, he cannot do patent for that particular invention. Okay, that is the reason. Is it fine?
Thank you, ma'am. Thank you.
Okay, okay. Anytime you please stop me. If any queries there, we will discuss that and then we will move further. Fine. The next now. Now the next thing is like a this next question. We will just go. Just check here. Huh. See this question.
Ma'am, excuse me.
Yeah, yeah, please.
Ma'am, actually, in yesterday's session, ma'am said that publication is a copyright. It can be patentable.
No, 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 no. Say again, something different might have been said. Publication is a part of copyright. See, in few minutes I will. Okay, what we will do? I will just finish. We will. Should I go to that first quickly so that any confusion should not be there?
Okay, ma'am. Okay.
Because there might be something different is said, because publication, okay, copyright is perfect. That is one part is there, but publication can be patented only when before going it for the publication you have to do the provisional application filing. Okay. uh, uh, I guess when we will go into the details now, I will just share with you that particular thing and then we will move further. Good, you have raised this point. We will discuss this. Okay. This one? Yes, because these are the scenarios we always see around.
There are some answers posted in the chat box, ma'am.
Oh, okay. Sorry, I have to see that thing. Right, right. Mhm. Thank you. Original inventor, Mr. Nagesh, but has not legally protected. Very good. The company, if they have developed the product, it is not in the original format. Okay. Um, Already publicly disclosed in the hackathon, the invention may not be a patentable anymore, meaning neither Nagesh nor the company can claim a valid patent. Okay. A patent will belong to Mr. Nagesh and his team as the true inventors. The company cannot own the patent unless the students legally assign their rights. Very good. Company should give ownership to Nagesh. Okay. Mr. Nagesh, but it can be subjective. No patent. Okay, fine, fine. Okay, that is a. Okay, now what I will do, I will just show you. Ah, so you have already catered things. Okay. So here we can say if this is the option, what you will choose, and then I will talk about other answers also. If this is the case, then what will be the option?
Mr. Nagesh.
Mr. Nagesh. Okay. Any other? Let me see the chat box. Mr. Nagesh, the fourth option. Okay. Okay.
On the agreement between Yashwant
Yes, that is the
Chavan College
fourth
and
option. Yes, Bhuvneshwari, Dr. Bhuvneshwari, yes. Fourth option, last option. Perfect.
Last option.
Perfect. Exactly, the last option. Huh? But the thought process which you have shared, it's a good, and the answer to this will be depends on the agreement between Yashwantrao Chavan College and participating organization. Now, one more, then I will explain why these questions I have taken. Okay, next one. So here, option in this case, third question. Yes, you can write down in the chat box. C. Yes, thank you, Dr. Kushbu. C. Perfect. Okay, then this one.
Option C.
Option C, the government of the country. Okay. Any other answer? Any other answer? Let me see chat box. Option A. Option C. Okay. B. Both all options you are writing. Okay. Actually, the answer for this is see, I should explain this point also because when we are entering into the patent, I will explain all the four questions. First, I have explained, right? Second thing is like this is a hackathons. See, nowadays everybody or many organizations are doing a hackathon. So the motive behind or objective behind sharing this is like that. We have to be very careful when our students are participating in these hackathons. I will suggest that whenever a student is participating, make sure that you have an agreement with the organizers if it is especially private organization, because I tell you this is like an idea mining kind of activities are there. By giving 1 lakh kind of a prizes, they are creating a pool of ideas which may be worth for crores of the product. So we have to be little careful, and therefore in such scenario, obviously what will happen as no kind of in this case, he has not put any legal, we can say, the instrument in place before participating. uh, Obviously what will happen, If the instrument is there, then they will kind of if that agreement is there, it depends on the agreement between Yashwantrao Chauhan College and participating organizations in the hackathon event. So it is suggested, and it is always a good practice to have an agreement between the parties so that the participants will be safe. In the third case, you can say that here it will be again a mutually agreed upon ownership arrangement. So before any collaborative work with any private or public or government, whatever that company or a government organization is there, we have to be very careful about the that agreements. Yeah. Somebody want to ask something? Anybody want to ask something? Okay. Now, the third thing I have just put, the next one is like a research institute to develop medical treatment, and that could potentially serve. Can we mute that thing?
Dr. S. Mahendran, your mic is on. Please mute.
Okay. The next one, what we have discussed is, I guess, about the traditional knowledge related, right? This one we have discussed, right? Then we have discussed about this one. Now, for this, answer is a no one, as biological resources are considered common heritage. So we have to understand that here you can see there is a Biodiversity Act is also there, and there is a traditional knowledge related, some protections are also there. So if some isolations are there for the new compound from a rare plant, it's only isolation we are talking about. So as it is only isolation, it is falls under the discovery, you can say. And then the discoveries are not patentable, and therefore there will not be any kind of a patent for this. Now, for using this particular extract, if something new having synergistic value addition, then that can be considered further for the patent protection, provided biological diversity board gives the approval for the protection for that particular that patent protection, because without that patent examination does not happen. Okay. And one more question is there. I guess we missed this thing. You just check that thing and please answer this. What will be the answer here? Unique process. Yeah, it is a unique process of isolation, Professor Rakesh. So that process is very specific. Process will get the patent, but here we are talking about that extract. That extract will not get the protection. That final extract, whatever is there, that will not get the protection. Okay. I guess, is it right, Professor Kumar? Yeah. Okay. Thank you.
Yes, ma'am. Okay,
Yes. Process will get that. Maybe that process can be patented, not a product. Huh? Yeah. C saying then balancing the interest of inventor with the public good. Okay. I will give you a hint for this particular question. Have you seen Section 3 of the Patent Act?
Yes, ma'am.
The now answer. Last option. Yes. Okay. Because as per Section 3, medical treatment, it is not patentable. Right. Thank you, Professor Shital. Thank you, Dr. Bhuvneshwari. Okay. So now, yes. No. And Professor Nivita, option C is not possible here. What is that? It is balancing the interest of inventor with the public good. It's like a not possible. This particular invention itself is not a patentable. Okay. Okay, last option is the right option.
Oh, ma'am, it will come under section 3I.
Yeah. So section 3 has a list of inventions which are not patentable in India, and this is one of the horticultural method, mathematical expressions. Then the
Is
new
IE is correct or not, ma'am? 3I.
sorry.
3
We
I
have to.
is
I have
correct.
to. Let me confirm that thing, because it is somewhere I or something like that. We have to just check that thing. Section 3 में, ठीक है? Medical things are not patentable in India. Even surgical methods, then horticultural practices, all these are not patentable in India. Okay,
Okay.
fine.
Like, is it only for equipments or for any drug also?
No, it is for the medical treatment. Treatment, like the process of that surgery or process of that treatment, that is not patentable. Drugs are patentable. Huh? Drug is a product. Otherwise, pharma industry will be like they will be like it will be a problem for that. Okay, so pharma industry is working on what exactly? They have a good number of a patent portfolio. So product is patentable. Pharma products are patentable, but surgical methods, how to do surgery, how to cure particular thing, that methods are not patentable. Okay.
Okay, okay, ma'am.
Yeah. So that is the scenario, and therefore that will not get a patent in India. Fine. So it is a section 3I only, right? Oh, so it is a section 3I which talks about the inventions not patentable. It prohibits the patenting of medical, surgical, curative methods, okay, prophylactic methods, then diagnostics or a therapeutic treatment, etc. So that is not patentable. Fine. Now we will
So, ma'am,
just move. Yes.
new equipment, it would be patentable.
Patentable. The patentable equipments are patentable, huh? Then the drugs are, then diagnostic tools are patentable. Please remember that diagnostic tools are patentable, because that we should know, because we as professors many time, if you are working, this is comparatively when developing diagnostic tools is comparatively easy research than developing the instrument and all, because we require a collaboration with a, if biology fellow is working, then he require a collaboration with other mechanical engineers and all other design, and then development and all that thing. So diagnostic tools are comparatively easy for development for us as a creators. Okay, so please remember that we can do patenting of that particular thing. Okay, now we will just focus on this quickly. We will just go through the basics. I guess already you have covered that thing, but now please understand that patent, when we are talking about, I will not go into the others, but I will just talk a little bit about patent, because for searching we should be aware about that particular thing. When we are talking about a patent, please understand that novelty, non-obviousness, and the industrial applicability aspect. And what patent searching we are doing is, it is related to the novelty aspect. So we are like entering into that one important section, that important criteria of a patent. So whenever your patent is examined by examiner, what is look into that three criteria, that novelty, non-obviousness, and industrial applicability. And the other one is like a section 3 and section 4. Please remember this thing. These five things are looked into very critically, because if unless the invention or innovation which we have submitted as a provisional application, and then may without provisional, or maybe it is filed as a complete specification, then we have to be very careful that whether these five aspects we have covered or not. Now, just now, madam has told about that publication. The two things we have to understand here. Whenever you are doing the publications, it is like we are, our normal practice is like we do publications, and we may not be aware about a patenting, and later somebody will suggest us, or later somebody will come say that, yeah, you should have patented this, or sometimes we also realize, oh, I should have patented this particular thing. So one trick you should do in such a situation, that first thing, before publishing में क्या होता है, suppose today I have written that paper, research paper. So what you can do that, I'm just blankly saying that thing and very clearly saying that thing. You file that research paper with some additions of details. Okay, some additions of details of your the research work, which is like for example, substantial means what I want to say is how I should say, research paper mein whatever you have given, no, time, that page limit is also there, so we have to remember that thing. 30 pages is a limit of the patent, but to not lose this particular thing on the invention, whenever you are writing paper, first thing you check that whether it is following novelty, non-obviousness, industrial applicability, section 3, section 4. Section 4 probably will not be question for you, but first 4 things you look into. If you feel that this criteria you are like passing it, then what you can do that, you just put the things as is, whatever your lab notebook is there where you have noted all the things, you put. What is important is a technical advancement. Please understand that thing. Your paper, your research paper writing style is different. Our patent writing style is totally different. For patent, what is important is a technical step, what your contribution is. So you have to very carefully add that particular contribution and into that write up. And in a crude way, I'm just saying that you may not know the how to draft a patent, but you note down that crude way the technical steps, and then you can file the provisional patent application on your own. Please appreciate that you can have your own patent application on your own. You can do that thing, and then simultaneously you can give it to the journal will take 6 months minimum at least for going through all that review and all that thing. And during that time you can contact the your IQAC and go for the patent filing. Probably that will be the right path, so that your patent will be in shape, and within 12 months you have to file the patent. That is important actually. So 12 months timeline is there. Within 12 months you have to file the patent. So follow that, so you can have your paper also, and you can have your patent also. Okay, so that I will suggest definitely. So publication and that patenting. So first patent, publish, and then we say that prosper. Okay, because what happens that if you have both things from your from your efforts, like whatever you have put, nothing like that. Okay, so just think about this kind of a that way whenever you are filing the whenever you are going for the publication. So publication, uh, whenever you are doing publication, what madam had said, that copyright, that publication copyright ka subject matter is like, if I want to give a subject matter of a copyright, it is literary work, dramatic work, cinematographic work, then there is a pantomimes, architectural work, then there may be that music. Okay, all these are copyright things, and this publication is one of the subject matter for the copyright. So that is a very different type of IP. Patent is a different type of IP. So these are totally different. Okay, so we have a, based on subject matter, we have 8 types of IPs are there. So patent, when we are talking, it is related to invention, innovation. Copyright, when we are talking, it is talking about a expression. So that there is a difference. So please, we have to appreciate that difference. Then other types are there, I guess, but that is not a topic of today. So I will just move to the patent strategies. But before going to that, if you have any comment or anything to say, yeah, let me know. Let us pause and let us know if anything is there to discuss. Okay, up to this point, it is fine.
Yes, ma'am.
Okay, fine. So now let us move to the next, that we have understood. Now we are focusing completely on patent. In that patent, we have understood novelty aspect is important, and why we are going to do search. We are going to do search because we want to know the novelty aspect. Now these are the some advanced fields of a patent, that auditing, portfolio valuation. If anybody here is from IQSC, probably the IP management, auditing, valuation is of their interest. Tech transfer, because you have to take further that development, that patent portfolio for the further commercialization. So you can think about this advanced things. Now we will go into the patent searching. So when we talk about a patent, we have a 3 different domains. So I have told that intellectual property, 8 types are there. In that 8 times we focused on patent. In the patent, now we are focusing on the that 3 types are there, or 3 domains are there: searching, drafting, litigation. Now searching and analytics is a one domain. which we science people are can contribute. And here we are like helping in the it is in short the data analysis, and the data is a patent. Okay. Another field is a drafting prosecution. If we want to do this kind of activity, then patent agent qualification is important, and we have to qualify that examination, which is conducted by CGPDDM office. And patent litigation is another area where you can explore the different litigations which are related to patent are coming up, and in the court of law you can practice that particular thing. So these are the three different domains are there. Now we are focusing only on the patent searching. We will keep aside drafting and prosecution part. If you see the current scenario, this is a 2021 patent filing actually. I just want to share this with you because we have to appreciate that one company like IBM, which was on top for almost 10 years, filing almost 8,000 plus patents, 8 to 9,000 patents every year. That was the aggressively patent filing happens by the Fortune 500 or the leaders in the country. So you can just check that these organizations which are there, these organizations 365 days, but they are filing 9,000 patents. So you can just imagine what is the speed of that filing. Now you can just check this particular diagram. Now here you can just check that different countries which are filing the patent, and you can say that China is on the top, then you can say USA, Japan. So in the race, we can say that we are like far behind considering our overall population and our intellectual capability. But China, USA, Japan, like all we can say these are the top in the IP filing. Now, when we focus on the patent searching, it is just like searching a needle in the haystack. It is such a difficult task because there are a lot of material which is available, and from that material we have to just search the patent or the other material which is related to our invention. Oh, this is a very difficult task. So I always feel this is a very right presentation for the patent searching. That if your needle or a small thing if goes into that haystack, how will you search? It is very difficult. How you can do that thing? So I will say that this thanks to the databases which are available, but these are only patent databases. Along with the patent databases, we have to search into the traditional knowledge, articles, all other publications, newspapers, everything you have to search and make sure that yes, it is really a novel thing and we are like creating a new thing, right? Now, when we are like doing this patent searching, always the questions are, why should we do that thing? Where we can get that access, when we can do that thing, or what will be the use of that particular thing. So all this when, what, why, all answers we will look into in this like a few minutes we can say. So when we are doing a patent analytics, we create a report like this, right? So when I was working in the organization Fortune 500, I was working in a patent team. So our job is like to create a landscapes with a single keyword is given to us. For example, I can just tell you invisible fiber, that was one of the project for me, or natural color, that is one of the project. Now with that keyword, only one keyword, I have to create the landscape, that what is going on in the particular that around that particular keyword, and then based on that the further research will be taken. So that kind of projects are there. Another kind of activity is like that with the patents analytics. Whenever we are doing, we keep a watch on our competitors. So we call it as a competitive intelligence. So we will come to know that what our competitor is doing and what will be next step. So we can predict that particular thing, and then we can plan our R&D accordingly. That is a competitive intelligence. Okay. Okay. Voice is breaking or it is correct? Dr. Amol, it is correct or not?
Yes, it's working fine, ma'am.
Fine. Fine. Okay. So the point is like that competitive intelligence, novelty search, or FTO, freedom to operate search, invalidity search. So these are the different kind of a search we do and the objective for each search is a different. Now, when we are doing this patent searching will be for any of this task, either for FTO, either for novelty aspect, either for the that landscape preparation, any aspect will be there. Now we are probably, I will just say that we will just go into the details of the novelty search. What that is a search which is done before filing the patent. Okay. Now, when we are doing this patent searching and analytics, why you can, what is the benefit of doing that searching? And these are the different applications you can see, that you can avoid duplication. There is a creative thinking, that problem solving, that you can get the solutions to your problems from that patent searching. You can plan your R&D. You can check the technology trends. You can prevent a litigation and infringement. Whenever you are going in mergers and acquisition, that activity is important. When you are doing for a licensing or tech transfer activities, licensing is one of the way of tech transfer. There are many other ways of technology transfer. So whenever you are entering into that, you can do this patent searching, or whenever you have to gap the technology, bridging the technologies, you can do this patent. So these are the few, I will say, the benefits I have just shared with you, but there are lot and lot benefits of a patent searching. Okay, let us take a pause here and let me know if you have any question so that we can address that and then we will move further. Any question?
It's clear, ma'am. As of now, no questions.
As of now, clear. No? Okay, thank you. Okay, so next what I have to show you here is we have to check the patent document actually. So what I suggest, I hope that you have gone through the patent documents, but if you have not gone through any patent document or like that, what I suggest, you just go into the this Google patent simple, and try to kind of download any patent, simple patent. Don't go into the complicated patent thing. Simple patent you try to extract, and then what you can do, by extracting that particular thing, try to read that patent. It is a, if you have not read patent before, it will be very tiresome, but if you have done it, if you have a practice, you can read patents very easily. So maybe if it is first time, you may take little more time to read the patent, but if it is like, if you have a practice, you can do it easily, that reading. Patent is a very structured document actually, but it is a techno-legal document. Okay, so I just remember one of our client actually, he has given his details of invention. We drafted it. FERK means, in the procedure what happens, you submit, it publishes after 18 months, and then the FER will be issued. That is a first examination report comes. Then we have drafted our reply based on that, and everything was done. And at that time, we have that client came to meet us, and we were having some queries related to FER reply preparation, that I have just shown him his draft. Okay, he has gone through, and his reaction, as I till date I am remembering his reaction actually. He was so irritated with that particular thing, so surprised. That was a mixed reaction: irritation, then surprise, and that it is like some pain in reading. All this kind of reactions are shown because he could not understand this is his own invention, it is drafted in that way. So that is the scenario actually, because what happens, as a science student, we are writing it, and as a research publication, whenever we have to do, we write in such a way that everybody should understand, everybody should get access, everybody should read our article. But when patent drafting comes, what we do, we make sure that they will not able to mining means they could not able to take out our patent, they will not able to read it properly, they will not get the information properly. Means we draft in such a clumsy way, a complex way, so that we are keeping the inventor safe. Because patent, the main motto for patent is a wealth creation. We are not like announcing, oh, I have my patent, I have patent, my number is given. If you are entering into entrepreneurial activity, and if you are doing this advertisement that I have a patent, then you yourself are killing the competitors for you. So you are creating competitors for you. So patent is like a very subtle way it should go in the competition. It is better that not disclose, let the competitor find out that particular thing. That is the case actually. Okay. This patent, when we are talking about, it has a structured document. So first page is a bibliographic data is there. What is bibliographic data is there? This is the first page, whatever is kept here. Now there is a name of inventor, there is name of assignee or applicant, then there is a title, then there is a examiner's name. It is a US patent. If it is in Indian patent, it is not there, but if it is a US patent, examiner's names are there. Then there is a IPC number, that is International Patent Classification is there. Then US classification if it is US. If India classification is there, our code system, that our classification number will be given. Then when it is filed, when it is like applied, every detail of this patent will be given along with the some number. It may be patent number, it may be application number, depending on the status of that particular patent application. Okay, so all this information is there on the first page. This is what the first page is, right? Then the next, these are the different parts of the patent document actually, now that we will go. But on the bibliographic, that first page, you can get all this information I have told you. And then if I want to say the structure of a patent, the different fields of a patent document are field of invention, then background of invention, then there is a that object of invention, then summary of invention, then there is information about drawings, so figures is there. Next is a description is there, then best examples may be given. Then there is a finally, after everything is explained and all that thing, lastly there is an abstract, and then there is a claim part is there. So these are whatever are there, the structure, like our research paper have a structure, like a introduction, material method, then data analysis, result and discussion. First we will give the abstract, lastly we are giving the conclusion, we are giving keywords also. The structured format is there, right? Similarly, patent, any patent you take from any country, this format is followed. And the bibliographic information, the search fields for you when you are going for searching is a application number, abstract, then there is a date, or that is application date is there, filing date is there, assignee name is there, you can see here, claim is there, description is there, priority information is there, international patent classification is there, inventor name is there, publication date is there, patent number is there. So all this information is given by the patent, and based on that you can do the search. Okay. I would like to take a pause here, and if you want any explanation for anything, let me know. Then we can move to the further points. Is it okay?
Yes, ma'am.
Fine. Next is this. Okay. What I suggest you now, can you do one exercise actually? Take 5 minutes. You can open a Google patents and write down keywords of your area of research and download a one patent document. Can you do it, please? Or you can give me that. I can do it here and we can together do the exercise. Let me know how you are comfortable. Yes? How you are comfortable, whether I should do it on here and we can look into that, or you yourself will do. You want me to do the search? Or you all will download on your own?
We will share our document, ma'am.
Mm-hmm.
We will share our area of document.
Okay, fine. Huh? I have to then share my entire screen, I guess. So let me share entire screen so that I will stop this sharing and share the entire screen. Let me do that and then we will go for it. Okay. Mhm. Let me know just if you can see the.
Do we need to share the PDF here?
I will do now. See, here. Are you able to see the screen?
Yes,
Google
Yes,
patent.
ma'am.
Now see, I'm writing a
Yes,
Google
ma'am.
patent. Okay. This is a simple database available, freely available. I have opened it, right? Bioenzyme, somebody have shared the keyword. I'm just writing it. Fine. You can just see here, lot many patents I have got. Should I open the first one? It looks Chinese document. Bioenzyme. Okay. Which one I should open? Let me know. Dr. Renuka, can you just tell me which one I can open?
Ma'am, we can use bioenzyme as a product for agriculture.
Agriculture. Okay.
Yeah,
So
agriculture
we can
methods.
agriculture. So
Yeah,
let
for the
me
growth
add.
of plant promoting factors.
Okay, so I will add that thing.
Okay.
Agriculture. Okay, and you want a plant.
For
You
plant
said plant
promoting factors, as bioenzyme can work as a plant promoting factors.
promoting factor. Okay, plant and promoting. Let me see if it takes all.
Yeah,
Hmm.
I'll take some.
See now. No result. Promoting, I will just remove it. Huh. Okay, so eco-friendly fertilizer compositions, plant regulator containing fertilizer. So we have a wonderful paper planting method for overcoming continuous cropping obstacles and all that thing. Should I take first one? Again, it is Chinese. चाइनीज में क्या हो जाता है ओरिजिनल डॉक्यूमेंट हमको यहाँ ठीक है आई विल डाउनलोड दिस थिंग ठीक है सो ऑस्ट्रेलियन पेटेंट ऑफिस एप्लीकेशन नंबर हाँ ठीक है आई गेस फाइन एब्स्ट्रैक्ट ओके गुड fine okay you just see now what is the title you're unmute all of you please and let me know what is it I will just put this what is the title of this patent
Pepper planting methods for overcoming
yes
continuous
yes
cropping obstacles.
yes when it is filed what is the date when it is filed date of filing
28/5/2020. 28/5.
yes okay
2020.
so 20th May
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 2020.
2020 fine publication date publication journal date granted journal you can see here who is the
9th
inventor
July 2020. 9th July.
right who is the inventor
Germplasm Resource Research Institute of
he's
Ningxia
a
Academy of
applicant
Agriculture.
this is the applicant inventor is
Gavo Jingxia.
Jingxia or
yeah
Z.
yes perfect okay now we have to remember one thing he's an inventor these are the inventors these are the applicants when we are talking about patent please remember all legal rights are with the applicant so inventor does not have legal right we be aware of this thing generally we forget because we all as a teacher are mostly inventors our university is an applicant actually right so please remember that thing and check your policy what your IP policy says about your benefit sharing regarding the commercialization of IP but this part we should be aware about okay so this patent is filed in 2020 so it is very recent patent I can say and it is still in application stage you can see here A4 is written now so it is a application stage and it is from Australia AU so these codings are there and based on the codings you can judge all these things fine now we will go to the little bit more details of it here is abstract For abstract, the rule is of it should be of a 150 words actually. It looks it is following that particular thing. Okay, then you can see the this thing. Technical field is there, background of technology is there, invention summary is there. Very simply drafted patent it is. Detailed description is there. I guess it is very easy to read and understand. It is not that complicated. Huh? Very simply drafted patent it is. Technical proposals are given, the data is given, all experimental data is given, and then lastly the claims are given here, right? And then how many claims are there? Let us see, 10 claims are there, and this is a 12-page document here. It is uploaded, right? So look, you can, this is, I will guess, I have to check the novelty and other aspect, but this is a very simple way of drafting, and definitely we can do easily this kind of a drafting. I will just share this patent in the chat box. Let me write down it if I can share it, so that I found it. I feel that you all can go through it. It is very simply drafted. I will not say it is correct or wrong or something like that, but this is a very simple way of drafting, not clumsy, not complicated. You can also try this particular kind of a drafting. It will be, I don't know whether it will be granted or not. We have to check other aspects for that. But I'm writing here the name and the details actually. So maybe you can check this whenever you will get time. Maybe you can just try to read this particular patent. Okay. I'm not endorsing, but I'm just saying that the way of writing is very simple. So it's like somebody uh, matlab, it's not like that. If you have a very complicated way and all that thing, then only patent will be granted. In a simple way also you can write following the guidelines of a patent act, then also you can get the patent. That is not a big deal. Okay, so you can just go through that patent. Okay, let us move further. What we can do, we have identify various fields. Okay, we should go where to search. Google patent is one of the very good database, I will say, which is publicly available. A few other databases I'm just writing down in the chat box. Please take a look into that. You can open that. SpaceNet, eSpaceNet. I'm always happy if there is a free databases. eSpaceNet is a wonderful database, and then every country office have a database actually. So you can just go through that particular database. Okay. Why to do patent search? I have already shared with you, right? That mergers and acquisitions are there. Then problem identification is there. Prevention of duplication is there. Technology transfer, if I have to do. If I have to do the cross licensing. If I have to kind of check that invalidity, that is in infringement related search. If I have to do, I do invalidity search. If I want to know the progress of the particular field, I do a landscapes. So there are different kinds of search, and different kind of objectives are there when I am doing the search. When to search? If I am filing the patent, before filing the patent you should do the search. Means whenever I do this patent filing, I always first whenever the details comes to me, I first will do the patent search. I should be confident about the that novelty aspect, and once I get that confidence about that novelty aspect, then only I draft the patent. So that is one time when I will do the search. Second time I do search when I do these projects like of IP auditing and all. At that time I do little bit of a patent search to get the idea about the field. Then whenever I'm doing IP valuation related projects, I will do this patent search to get the idea about the how uh, how advanced that domain is and how the competition is there. So at that time I do this kind of a search. When there is events like mergers and acquisition kind of events are there, at that time we will do the patent search to get the again at that time we have to see how our that partners that entering into that particular deal are doing in that patent field. Then at that time we are doing the search. Then whenever I have to do the technology transfer, definitely at that time I require to do patent search. When I want to launch the product into the market, Before that, I do patent search, that is a freedom to operate search actually, right? If somebody have filed case against me related to patent, then in such kind of a situation, I have to do the patent search to check the validity of the patent, right? So these are the occasions I have shared. At that time, I am going to do the search. Then what to search? What exactly you are going to search? So based on the right objective, I have given you different scenarios when I am doing the patent search: auditing, valuation, mergers, acquisition. Then I'm doing this search for the, maybe when I'm like uh, doing this the tech transfer related activities. So depending on that activity which is I'm doing, accordingly my focus will change for the search. How to do search? We have just simply see the Google patent search. It's a very simple way of doing the search. Whatever your keywords are there, you take it, put a plus sign in between and put it together, and you will get the patents which are related to that area. Similarly, you can go for eSpaceNet, and eSpaceNet have a different way. You can just go into that, and you can just check that there is a that the search like tool is toolbar is there. There you can do the search. Then there are different ways actually in eSpaceNet. Whether you want to search that keyword in abstract, whether you want to search it in the full content, or you want to search it into the claim, that is your choice. So that options are also given. Okay. Now the point is like that. Please remember that when I'm doing this particular search, I'm just talking about this free databases. Working with a free database is little bit a challenge, because unless until you are expert in that, you will not be like come to the conclusion about that particular thing unless until you do the proper search. Otherwise, what will happen? You will search, then you will say that, oh, my this thing is not there in the database, so it is completely novel thing. So please remember that it may be your fault of searching, because whenever we do search, the scenario is like that. When the inventor shares the details and I do search, if something I get into the patent, into the eSpaceNet or in the Google patent, I will be very happy that, okay, very happy for myself for doing completing the search, but unhappy for the inventor that no, his patent, this thing cannot be patented. We have to stop here. But what I can do, I can give him the suggestion that here are the lacunas, and you can go further research in this particular white spaces are there, and then maybe after 6 months you can come back, and then we can go for the patent filing, because probably you will get something new there, because that area is not explored. So therefore, when I will not get, I will be at attention that if I will not get anything on eSpace in it related to that invention, then I have to spend lot of time on it until I get something, because there is no chance that something has not happened into that area. It is like we always say, na, we are like on the shoulders of the giants, we are growing further and further, right? So we have to remember that particular thing. Okay, up to this, I will take a pause. Let me know if you have any query. I quickly go back and run slides so that if you have any query, you can just ask me. We have started with this. We have just discussed the few objective type or MCQ type of questions to set the background. We have just focused on here patent, right? Then we have moved further, and we have just understood that is in patent also 3 different areas are there. This is the filing status, and then we move to that patent searching, that analytics part, and these are the different applications. A few applications I have shared. This is a patent document. Bibliographic data is there. Then these are the different fields I have shared with you, and then we have done a small exercise about the identification of various search field by the keywords which you have given, like bioenzyme, and we have got the patent, and we try to understand the few that particular. So I'm just giving you the glimpses so that you can practice on your own this particular activity. I tried, and luckily we got a very simple patent document actually, and we have done with that particular thing. Okay, up to this now. I take a pause and let me know if you have any query. You can write in the chat box.
Hello, madam.
Yes, Dr. Shekhar.
Madam, please elaborate the process of publication and the patenting. Madam, same time you told us earlier, but still I'm not clear actually how to
Ah,
go for it.
Okay,
Yes.
that is very important for us actually. We are the inventors and creators, that authors both actually. When we say patent, we call it as an inventor, and when it is a copyright, we call it as an author. So our always normal practice is what whenever we got something and we say that now yes, I am at the position to publish, we start writing research paper and we communicate with the journal. And this is our normal practice. But at this juncture, just stop there, look towards your invention, ask yourself whether this can be patentable. So you ask the three questions: whether my invention is a novel in the world. That is the first question. Next question you should ask that whether it should have an industrial applicability. And third, you should ask about the non-obviousness aspect. And after, if the answer is yes for all three, then you just check that section 3. You can just type in Google patent section 3 and you will get the list of inventions which are not patentable, right? And based on that, once you are clear that yes, my invention is, this thing is patentable, at this time you have to take a pause. You have to stop here. Before sending that paper to the publication, immediately you have to draft a provisional patent application. So what that provisional patent application is, I've shared with you one patent just now. The number is there. Simple draft. This is a very simple draft actually. Luckily we got that, such a simple thing. So you can just see that and try to draft your research paper that is ready. From that you try to create the draft for the provisional patent. Only thing is, don't write claims. Claims you please never write, because you are not expert in that, and if you do mistake there, you will win the loss. So don't draft patents. Baki, whatever the remaining things are there, you can just take care of that and file the patent. Filing patent is so simple, I tell you. Online you can do that thing. Online you can open the account, and if you have that digital signature, you can immediately you can submit by giving 1600 rupees, only 1600 rupees, and you are secured actually. And then you can give for the publication. And only thing you have to remember that once you file provisional, within 12 months you have to complete the draft. You have to add that claims and all, and you have to submit that complete specification. So this is the kind of a situation. If you do this smartly, probably you can have both publication and a patent.
If it is published before, madam, before granting the patent, then
That is okay. That is okay. But once you have filed, granting is a different part. Application number should be before publication. That is important.
okay.
So,
Okay.
matlab, whenever I file the application, no, I immediately get 12-digit number to me. Okay, and that is the security for you. You need not to worry of the grant. Grant maybe after 10 years also you need not to worry. You have to just file it, and your application number is important. 10
Okay,
years
ma'am.
is a very old case now. It never happens now. Within 4-5 years maximum. Now that the timeline is reduced. So within 4 years also, 3 years also patent. Rather, if it is express publication and examination, within 13 months also patent will be examined and result will be out.
If a lady candidate is there, madam, woman candidate is there, it can be granted, I think, in 8 months like that, something with short
And,
duration.
yeah, means they have that that early publication, and that kind of a provision is there. That is true. Yes.
Yeah, and then if it is published also in 3 months, 2 months time, the journal,
That is
then no
fine.
problem, madam. Fine. Okay, it will
No
be
problem.
granted, right?
No problem. Yeah.
Yes.
The point is like once you file it, you get the application number, and that
Yes.
application number is a unique in the total world. That number is with you only. That is just like our Aadhaar is only limited to India, but this number is like a very unique in the world actually.
But ma'am, suppose if I go for Indian patent, right? I'm not going for
No,
US or world over.
fine,
Fine.
fine.
Yeah. Because the novelty work, the work should be novel, fine. But madam, mostly, and doing a novel work is very tough. So sometimes we do in the our Indian context or regional context, and in that case, it is
Huh,
a novel. So will it be fine, or it should be novel
huh.
in the world, or it should be novel in the
It
country
should
itself?
be, no, no, it should be novel in the world. That is very important.
Novel in
It
the
should be
world.
first. Novelty aspect is a world aspect. It is like a, we look into patent ka wahi challenge hai. It should be first time in the world.
So they will not see for the from the Indian context, right? That because I am
No,
filing
no,
for
no. Patent
Indian country.
examination never limited to any territory. Any examiner from anywhere, it will look into. Even we do the patent search, we do look at a whole world. That is the case.
But suppose some patent is granted in US or UK, that is not very in that in other countries. How is it possible then? Like means, uh, are you getting my question, madam?
So yeah. I guess you are saying that some patents are getting grant in USA, but that grant is not possible. They have not received that grant thing in India,
Yes.
right? Huh?
Yes. Yes.
So I so told na this our section 3 is very critical. So we are like very critical about that. If it is coming under section 3, that patent will never be granted. And therefore, these big giants, Monsanto, Novartis, they are fighting with the Indian Patent Office for granting
Yes.
of that. The cases are going up to Supreme Court and turned down there also, because our Section 3 will not allow that thing, and it is good for us as citizens of India. We are lucky in that way, and therefore our medical that treatments or food is like affordable to us. This is not the situation in USA. If you see the scenario, it is a that medical treatment is a very challenging there. Food is very challenging there. Farmers are at a risk actually because of Monsanto. All this like bad side is there, which is probably many times we are not aware about that, and this is a bad effect of the patenting, and we are like safe because of Section 3.
Yes, ma'am. Okay, ma'am.
Ah,
In near future, if we need some help or consultation from you, I think
sure,
you can provide this. Yes.
sure,
Thank you.
sure.
Thank you.
Okay. Yeah, Dr.
Ma'am,
Yeah. Yeah. I've seen your question. For
ma'am,
receiving grant, we need a lawyer. Actually, I told you, for provisional patent filing, you yourself should do, because I have when I do practice, I've seen certain cases of theft also. I'm sorry to say that. Mostly the things are taken care by, but I will say that you do provisional patent filing on your own. It is very easy, and then you can, once it is like filed, nobody can do theft of that, because it is such a secured with the patent office that nobody can copy. But now the next step is a claim drafting, no? So I will suggest for claim drafting you should hire a services of a patent agent, and get that drafting done, because and patent search also, because patent search and claim drafting, these two areas you will need help of an expert. Other things you can do on your own, considering I have told you that there is a draft is there, you can do it easily. So you can bargain on the, I'm just saying it considering inventor point of view, that you can bargain on the price of the patent drafting. If it is a 60,000, 70,000, like for a drafting, you can say that all other draft is ready, we will require your help for the that claim drafting and hearing of that particular, because these two, if you are drafting, is again very critical. So if you are drafting, claim drafting, these two things, you can take a help of the law, that patent agents, and you can save on the money in that way. So this can be the strategy to saving also and to be safe also. Is it okay?
thank you, ma'am.
Yeah. Fine. We have, I guess, only 7 minutes now. So I will just show you that few things. This is the old style. I have shared this with you. Paid databases is another one. If you get by chance access to paid databases, and that is nothing like that, because some paid databases like Clarivate, Atsevier, these are wonderful databases. Means if you are not expert also, you can do the search. Then you will not require a help of any expert. because if free databases are there, definitely you will require a help of a expert actually. In paid databases, mostly it is a value addition is there. So with normal keywords also, the many patents which are like hidden, that will be retrieved. But still, what is my observations that sometimes overlapping is there, identical, whenever, especially when we used to do patent landscapes, no, we used to get little bit that download when we used to do the Excel sheet. Cleaning of Excel sheet is one of the tasks for us. That unrelated patents also come, so we have to do that cleaning. So it is a little bit master is required, especially at this field, that searching and then claim drafting.
Ma'am, what about Excel Scout?
Excel Scout is also there, but I guess why I'm definitely, but these are the all paid. Relicura is there, Crystal Orbit is there, that all these databases are there. But I will not endorse any of the database. You can try with all. But I have used extensively Thomson Innovation, which later known as Derwent Innovation. Now it is known as a Clarivate, and I found it is more like value addition is more in this particular database. That is what my observation is there. Recently I was talking with my students who are now working in the corporate, and then they are saying that, madam, along with Clarivate, PatSphere is also good. That is their observation, my observation. So I will not endorse, but this is like the scenario I am just sharing. Okay, so databases are different databases. You can try, take help. Then STN is there. It is a very costly database is there. Very costly database. So there are lot many databases are available. Cost is a major factor. You have to take into consideration. But December, if you get that access, nothing like that, I can just say. Okay. Okay. And Boolean logic is there in the patent searching actually. So we have to use and or truncated options are there. So whenever you will go further into that, then you can kind of build on this particular thing. These are the website. And I will just conclude with this thing that problem statement identification is the first step you have to do. Then next step is a keyword identification is there. Then you have to choose the databases in which you are going to search. Then you have to check the outcome, and then you have to that present in Excel sheet or a Word, whatever way you have to do that. And then based on that, as a team, that you may not require step for you, but we used to do it when we used to do the landscape and all that thing. Obviously, we have to do the graphical representation of data and find out the projections that we used to give prediction that okay, this is the this, so possibility, this is the possibility. So that kind of that insights from that data we used to share actually. Okay, so if you want to know more about this, these are the few free courses I have recorded. um, so you can just try out, it is freely available. And for patent especially, I can suggest you roadmap for patent creation. It is completely dedicated for a patent. Introduction to IP, it is covering all types of IPs. Entrepreneurship and IPs for students or faculty who are entering into entrepreneurial domain, and if they want to uh, design their strategy, then probably this course will be of help. IP management and tech transfer is more little bit for the managers and the IQSC people. If you want to do the tech transfer and you want to manage your IP cell, IPR cell, then that will be the useful. And IP dispute I recently recorded because through this NPTEL courses, when I was like doing live sessions and all, student used to learners, no, not only students, faculty, research scholar, they used to ask about some copyright related theft and patent related issues. So I recorded this course also, and I guess this is covering all types of IPs and disputes which are faced by this we can say in copyright, for copyright, patent, trademark, industrial design. I tried to cover that particular thing. Okay, so I guess I'm well in time. I'm closing it because another speaker probably you have to go for that. So I stop here. If you have any questions, let me know.
Ma'am,
Is
it
it
was
fine,
very good.
Professor
Yeah,
Shakti?
fine, ma'am. It was a very good session. I have completed your course NPTEL roadmap for patent
Oh,
creation. It was
yeah,
very
yeah.
wonderful. It was very wonderful, and I have learned so many things in that. So, if I have anything in future, can you please give me an email ID so that I can write you?
Yes,
Uh,
yes, yes, yes. I can
Thank you.
just write down. Thank you
It was
so
very,
much.
very wonderful, informative session, ma'am. Thank you.
Thank you. So I'm just writing my mail ID here, so you can write down. Thank you. Thank you so much.
Thank you so much, ma'am, for delivering lecture on patent search strategies. It was very informative. Almost, I hope everyone has benefited on how to search the patent in different aspects. Thank you so much, ma'am, for spending your valuable time with us.
Thank you. Thank you. Thank you for the opportunity to interact with all professors here. Thank you so much. And if you have any query about this, feel free to ask anytime. Thank you so much. Thank
Yes,
you.
ma'am. Thank you. Thank you, ma'am.
I take a leave.
Thank you.
Thank you. Thank you.
Thank you. Dear participants, now we will move to the second day, session 4, on the topic by Dr. Maithili Saravanan from North Carolina University. So I invite Dr. Rashmi for the guest introduction.
It is my privilege to introduce Dr. Maithili Saravanan, a senior regulatory medical writer and research scientist with more than 10 years of experience in molecular biology, neuroscience, oncology, and pharmacology. She has worked extensively on clinical and regulatory documentation for phase 1 to 3 trials, including protocols, investigator brochures, clinical study reports, and CTT submissions following FDA, EMA, and ICH guidelines. Dr. Maithili has been part of NIH-funded projects contributing to biomarker discovery, therapeutic protein development, and neurodegenerative and cancer research models. At present, she serves as a research scientist at the Biomanufacturing Research Institute and Technology Enterprise, North Carolina, USA, and collaborates across interdisciplinary teams to deliver high-impact translational research. She has over 25 peer-reviewed publications, serves as a reviewer for more than 60 reputed international journals, and has presented her work at international forums. She also brings academic experience as an assistant professor in India and research expertise from institutes like Hindustan College, Cox Life Sciences, and Central Leather Research Institute. Dr. Maithili holds a PhD in biotechnology from Bharatiya University and has earned several certifications in biosafety, clinical trials, and regulatory writing. With her strong contributions in both science and regulatory communication, she continues to bridge research, development, and healthcare innovations. We are honored to have with us today. Now the session is yours, Dr. Maithili.
For the nice introduction. And it's really a great privilege to be here and looking forward for the session. Good evening, everyone. It's a privilege to be here and to talk about the unlocking innovations, the crucial role of research in advancing medical therapy. I'm Dr. Maithili Saravanan, regulatory scientist and research scientist in biomanufacturing research and technology enterprises, North Carolina Central University. Well, Welcome to today's session on how research unlocks the future of medicine. The session is split into three different sections. First section is like cutting edge research is the starting point for every medical breakthrough. The transnational studies and IP turns discoveries into therapeutics that change lives. Collaboration, scientific rigor, and regulatory insight, which fuels the innovation from bench to bedside. So behind every major healthcare breakthroughs, whether it is a revolutionary cancer therapy or life-saving vaccines, there is something crucial but often invisible: the intellectual property right. The IP is not just a legal concept, it's the engine that transforms scientific discovery into real-world treatments, giving inventors the confidence and the research to bridge ideas from lab to the patient's bedside. When we think about the healthcare breakthrough, these kind of therapies, for example, CAR T therapy that changes how we fight cancer, or the vaccine that have saved millions of lives. The intellectual property right is not just a legal tool, it's a backbone of innovation. It gives us the researchers, entrepreneurs, and the companies the confidence that if they invest the years of effort and billions of dollars into developing a therapy, they will have a fair chance to bring it to patients. Without IP, many discoveries would stall at the laboratory benches. Why? Because investors would hesitate to fund high-risk projects, government would be reluctant to provide long-term support, and the therapies were urgently needed might never reach the people who need them most. So when we talk about IP in healthcare, we are not talking about patents, trademarks, and copyrights in the abstract. We are talking about the very best systems that fuels the cycle of research, development, and delivery. It is the engine that turns an idea into treatment and the treatment into hope. So there are three pillars of IP in medicine. The first pillar is the patent, which protects the scientific breakthroughs themselves and the molecules, the process, sometimes even the biological construct. Think of CAR therapy. Without patent protection, the years of research and billions of dollars could easily be copied before the first patient was ever treated. Patents ensure innovation can survive the long journey from lab bench to bedside. The second pillar is trademark. The trademark protects something different, the trust. The name like Covaxin and Catridin are just labels. They carry reputation, safety, and reliability. When a doctor prescribes it or a patient agrees to take it, the trust matters. The third pillar is copyright. We are often unlocked, but they protect massive amount of knowledge create alongside the way. The clinical trial data, the digital algorithms driving AI discovery, even the training material for the next generation scientists. Together, these three pillars just not spark innovation, they sustain it, scale it, and build public confidence in it. That's why the intellectual property right is not a legal safeguard, it is the invisible architecture that holds up modern healthcare. We'll see about a case study how the CAR T therapy got patented. Here is the reality. Without IP, these systems break down. Investors won't take the risk. The government hesitate to lean the support, and too often the brilliant therapies never leave the lab. The CAR therapy in 2007, the world witnessed something extraordinary. A child in the United States was cured for a leukemia through Kyrem, the first approved CAR T therapy. But science alone does not make this happen. That breakout was possible because the University of Pennsylvania patented the construct, and now it has secured the license. The combination of science plus IP protection gives regulators, investors, and physicians the confidence to move forward. In the world, IP is not just protect the discovery, it pave the word that carries invention from lab to the patients. So in Indian perspective, balancing innovation and access. Now let us turn the India's perspective because it adds an important dimension to this story. Our landmark example is Novartis Galvik case. The Novartis sought a patent for new form of its cancer drug, but Supreme Court of India said no because the new form did not demonstrate enhanced efficiency of the drug. This was more than a legal ruling. It was a principal patent must reward genuine innovation, not the incrimination tweaks. The decision ensured affordable access to cancer treatment for thousands of people, showing how India balances the rights of inventors with the need of public health. The another global contribution is the traditional knowledge, the digital library, the TKDL, the Indian catalog, the centuries-old medicines and the culture knowledge to stop misappropriations. A well-known example was turmeric wound healing properties. A US patent has been granted, but India challenged it by presenting documental evidence from ancient Ayurvedic texts. The claim was overturned and the patent was withdrawn. A global precedent set against biopiracy. In both the cases, India shows that protecting innovation and protecting against the access can go hands in hand. So choosing the reflections, the choosing the perfect IP strategies is a game changer. To think about your own work, how you can able to patent your own work. That's truly whether your work is truly patentable, what knowledge should remain as a trade secret, and what could grow into a brand. These are not just legal questions, they are strategic choices that chooses and determines how your innovation will live, scale, and impact the world. Now we'll see how the global trends and where India's position in the global trend. Globally, healthcare is evolving at lightning speed. The precision medicines, cells and gene therapies, and AI-driven diagnostics, innovations is happening everywhere. So where does India stand in this race? Well, our position is unique and it's growing stronger. We lead the world in generic and biosimilar supplies, which makes the medicine affordable to countries across the globe. That's why India is often called as the pharmacy of the world. Our startup ecosystem is thriving. An organization like DBT and BARC have backed thousands of biotech ventures and fueling research with funding, mentorship, and infrastructure. And we are also protecting our roots. The traditional knowledge digital library ensures that our ancient wisdom, like Ayurveda, cannot be misappropriately used by the international copycats. So India always has its own standpoint to protect the ecosystem when it comes to our traditional medical system or the modern technology. The government always they are backing up the maximum they can able to support the upcoming innovations and how the people will be benefited out of the new inventions. And the other important thing that need to be kept in mind, always the Indian medical system is more affordable than other parts of the world. The best example is the NextCare 19. It's an Indian homegrown CAR-T breakthrough. India's breakthrough in CAR-T therapy is very significant. This drug is approved last year, and here is a fresh story that captures just how far India has come. Last year, NASCAR 19, the first Indian CAR-T therapy was approved by DGGI. It was developed by AICTE, a snip out from IIT Bombay. So now why this is important? Because the cost alone makes it revolutionary. The similar CRT therapies abroad can cost 3 to 4 crores. The NextCare 19 is available in India for 13 to 40 lakhs. That's nearly a tenfold difference in affordability. But it's more than the cost. NextCare 19 represents a full circle of innovation. It's a homegrown R&D, the domestic manufacturing, regulatory approval, and robust IP strategies have been holding this patent like very strong. And the architecture behind this patent is really wonderful because this drug is showing like very less side effect compared to the Chinese and US medicine. So with NextCare 19, India is moving beyond being just the pharmacy of the world. We are stepping up as a global inventor. So in recent times, we see people travel across the world to India for the better treatment and also affordable treatment. So let us see some example case studies in IPR, how this IPR shapes outcomes like through 3 different copyright issues that has been resolved. One of the important example is how the intellectual property shapes outcomes in Humira, one of the world's best-selling biological drugs. Abivit, it's not rely just on the single patent for Humira. Instead, it builds the many IP forecasts. First, the patent was on the core molecule. This protects the drug itself. Second, the patent on everything surrounding it, the formulas, the delivery devices, the derivatives, and even the manufacturing process was patented. And third, patent on clinical use and indications. This means that even if someone tries to work around the molecule, Abivit still helps control over how it can be prescribed and delivered. And by weaving together these multiple layers, Abivit extended exclusively far beyond the original patent expiry date. The results, Humira remains the dominant in US market until biosimilars finally entered in 2023. So these kind of the wholesome patent will give you the broad coverage. So even when people try to use any part of your innovation, they are bounded for the IP that you hold. So even in advanced system, our lab also, we face these kind of issues because Merck has patented a few plant-produced proteins. In their patent, they have claimed a word plant-based bioreactors. So whenever we try to present some of our innovation in that category, the Merck always comes and like, no, this cannot be patented and this cannot be marketed. So while filing your patent, the clinical terms and also the general terms are really important that you have to keep in mind. And there are like many legal experts out there. Like it's always better to go for like legal references and the regulatory people's advice before filing any patent. The words what you're going to use in filing your patent matters everything. So it's always good to like protect all the aspects of your finding. So another example is it's our own journey. Like we are translating plant science into neurotherapeutics. So like there are a protein called epoprotein. The epoprotein was commercially produced with some recombinant gene they have been engineered for stability, and the epoprotein was mainly like made as a recombinant uh, to make its stability to withstand in the system for more than 24 hours in the bloodstream. But the stability comes at surprise. It risks the like compound with very serious side effects. It causes hemorrhages and blood clot. So this brings to like a more of deeper thinking into our lab, and we started we started to produce epoprotein in plant. The plant has unique protein folding system, which makes the EPO produced in plant unique. There is a different protein folding, and the acylation part is little bit different in the plant produced EPO. So the existing EPO stays in the system for 24 hours. Our plant produced EPO stays only 2 minutes in the system. So that's why it's a very breakthrough in stroke medicine. And our EPO, like it shows like 98% of stroke induced, like prevent 98% of stroke induced brain damages. And so far in our long-term study also, we don't see any hemorrhage. And like this is going to be in first stage clinical trial near soon. And here we also faced a very big problem when we try to produce acylorepo in the tobacco plant. We see the chloroplast interference is very like dominant, and we are trying to increase the yield of EPO. Then we took another technology called glycoengineering. We are trying to modify the plant pathway, which it can able to activate the other chlorophyll, that heme pathway of chlorophyll biosynthesis, where we can able to produce like more epoprotein without any chlorophyll interference. So here, when it comes to filing for patent, like how can we file this one? Because the natural compound, even though we modified the protein folding, we cannot file patent on the protein. So we can go for filing the glycoengineering method that creates this safer version, or the formula or the delivery system, the construct what we make, that is like more clinically viable. So we can able to patent that. The new therapeutic indications, the neuroprotection, it gives the neuroprotection. It not only like clears the block, it also gives the neuroprotection. It heals the tissues. So we can able to file patent on that one. So the difference between the lab curiosity and the medical product has bring our EPO product here for clinical trial. So without IP, discoveries like Acyloro EPO stays confined in the academic paper or in the lab notebook. So with IP, we can able to move forward from bench to bedside, turning the promising science into therapeutics that changes like millions of life. Once it's going to come out, like we are expecting more people will be benefit out of it. Since our long-term study with aged mice, it's social like very promising result. Like with many batches, we have never seen any hemorrhage, and it also gives like 98% a complete prevention. And so the other interesting patent dispute is CRISPR-Cas9 dispute. So let us look into how the global battle that defines gene editing. So both UC Berkeley and the Bohr Institute of MIT and Harvard claimed discovery of CRISPR-Cas9 as a gene editing tool. The science was revolutionary. The way to cut and edit DNA with precious with application ranging from agriculture to human medicine. But where the intellectual property plays in key role. The UC Berkeley as a university, their timing and the way the university lab operates is completely different from where the industry like institute or like private institute, they like act in a very faster way, and the accessibility is like more easy in those institute. So the UC Berkeley's, when they come into conflict, like already MIT has filed the patent, so they couldn't able to get the IP for that. But UC Berkeley, Dr. Jennifer Doudna and Amal Kamstrad, they demonstrated the CRISPR could edit DNA in bacterial system. And soon after, the Broad Institute, led by Dr. Feng Zhang, and shows the CRISPR could be applied into eukaryotic cells, human, animals, and plant cells. The Broad Institute, they filed the patent application quickly and strategically through a fast-track system at the US Patent Office. They secured the first wave of board claim. The outcome, both the sites have contributed enormously through the science, but the Broad Institute has held the stronger patent with them, the rights to global licensing. So now, like, it's a huge market for CRISPR-Cas9. Even though the UC Berkeley, they have started the work way earlier than the Broad Institute, because of IP rights, they hold the entire like the market access. So the lesson here is the IP decides who controls the application and who collects the licensing revenues. Ultimately, who lead the field. And to recognize the contribution of people from UC Berkeley, the Nobel Prize went to Dr. Donna and Christopher for the scientific breakthroughs. It was the Broad Institute, again the commercial and strategic advantage, not because of the science alone, but because of how IP was managed well there. So like it's always good to go for a provisional patent to protect your IP rights. The takeaway with this is like what do with this CAR T therapies, the natural, even though like it's natural product or CRISPR gene editing technology, IP does not reward science, it dedicates leadership. So it decides who leads and who follows in the world of innovation. So now let us see, from the discovery to real world impact, how the journey goes. The discovery is like when you get an idea in your lab and your breakthrough and find and finalize which hypothesis that you are going to work, and it's where the journey begins. Then you come for a provisional patent filing to secure your intellectual property rights. And the proof of concept, the experimental evidence, and shows it can be worked. Even before starting of your experimental work, you can go for like a provisional patent to file your idea. Here in US, the provisional patent, they will be awarding 12 months time, but in India, sorry, like I'm not very sure how long they are giving time for the provisional patent, but the provisional patent can be filed like way ahead. So the preclinical testing, safety and efficacy is very important when it comes to investigational drug. So the preclinical studies is like a very safe way to trust, like a very safe way to trust and try your ideology. And the next comes in India, like you can go for CDSCO submission. need to move forward. From there, the innovation may be taken up through licensing to an established company, and you can launch a startup. And the another important path is the regulatory submission. The regulatory submission you can do through CDSCO, like organization, and after your application is approved and the license can be provided, and you can always go ahead and start your startup. And finally, we reach final step is like market introduction, and where the patients and society will be benefited, and there comes the post-market surveillance. And there are like key milestones in India's innovation pipeline. The Indian government has they have improved few sections to give more protection to the innovations. The section 3D, it's only like new and superior form of known substance are patentable. The minor tweaks don't count. You must prove improved efficacy. This is what stops like evergreening companies extending patents without delivering real innovations. The next one is Section 3I. In India, the methods of treatment are not patentable. But here, the opportunities, like you can patent devices, kits, and diagnostics, you can patentable. This opens the door for innovation in tools and technology that supports healthcare deliverables. And pre-grant opposition, like India allows anyone to challenge the patent application before it's granted. That means the applications are subject to public and peer sanity is like where the way that does not happen in any other system. Like India has this like unique opportunity, like when once it goes into public, always when you have conflict or you are doing similar work and you have been doing this work for a very long time, you have already if you have any documents that you can able to show to the patent office, and you can able to fight for your work. This is like very novel thing to Indian patent system. It's not available in any other part. And also Form 27. The patent holders must fill this every 3 years, and providing their innovation is being actively worked in India and just like not parked on the paper. So, and the key takeaway is like these milestones strike the balance, and it gives a true protection for the innovation while ensuring everything is publicly accessible and preventing like patent abuses. So India's pipeline is designed to turn the research into reality, uh, and it always helps us, the scientists and the companies, whenever they bring products, they always help them to get their full IPR and help them to like market their products. And the current funding situation in India for biotech innovations, the two agencies always stands out. BARC and the Department of Biotechnology, DBT. These are the two India's premier organizations that dedicated to support biotech startups and research. What does the support looks like in like current and past year? The start of the grant is like starts with 50 lakhs and it goes up to 70,000 USD. The targets are early stage startups and up to high impact innovations. So beyond grants, they also provide equality and seed funding and help startups to scale up from proof of concept to all the way to commercialization. So this is also like very unique opportunity you can able to get from two organizations. The support is not just financial; it also help the strategic covering products and development, technological validation, clinical translation, and regulatory milestones. So each and every stage can be funded, and they are ready to help you, and they are ready to help with all kind of technical and the law related things and the regulatory related stuff as well. So it's very important as a bench scientist or like a PI, people can always free to approach these kind of organization for funding. And the problem is like you have to prove the uniqueness. So it's always very good to plan strategically and execute the project. And also another very important thing is like the very special focus on global relevance, and where the diagnostics devices and advanced therapies are accessible to public. And India has now supported 5,000 biotech startups. More than 5,000 projects have been funded since BIRCP has started. The support span is like complete full arc from laboratory discovery to the real world launches. So the funding will be provided stage by stage, like for the initial initial finding to the invention. And you can able to like set up a small trial, and from small trial to like marketing and building a company. Here, like what I see from the previous funding opportunities, the message is clear. The India is building not just a publication, but market-ready biotech solutions. Like now, we see like Hyderabad and Bangalore is completely transforming from IT sector to biotech hub. And many biosimilars and pharmaceutical companies are like plants are establishing, and even many inventions from like other countries also, like the manufacturing unit is moving to India. So going forward, like there are like many job opportunities that is coming to India, not only in the IT sector but also the biotechnology and pharmaceutical sectors. That's like a very warm thing about Indian government. They support like all the fields equally. And the another important thing when it comes to innovation is the regulatory. The regulatory part is really important to get the approval. So the regulatory part, it comes in two sections. It comes in like ICH harmonization and the Indian patent regulation and marketing. So like the regulation and IP are like it's an alignment game. It has to go hands in hand. So the invention does not fail because of bad science. It often fails because of the patent and regulatory pathways are not aligned properly. As I previously told, the terms what you described and the overall coverage, the overall coverage what you are trying to get for your product is very important for it to stand in the like industry for longer time. So it's always go for a professional people and try to organize or write your patent really well that goes with the flow of regulatory law as well. So in India, the regulatory approval sits with the Central Drug Standard Control Organization, CDSCO. For clinical trial, your file CT04 for the application, CT06 for the actual permission. So the clinical trial, like it runs in two forms. So here the catch, your patent strategy must align well with the disclosure for regulatory review. If your claim does not label your like match your label, your protection will be weakened. So that's why, like, as a regulatory writer, we always like keep on checking with the agencies like advancement and what are all the current approvals and the law, how everything as completely goes as a package. There shouldn't be any loopholes or the pitfall in the application. So that's where like regulatory people jump in to help to make the application really stronger. So the regulatory person not only helps in filing the local patents, they also help in getting permission from EMEA, like Japanese Association, FDA, and like when they try to market the drug globally, like there are like different permissions and different kind of regulations when it comes to marketing in other country. So while filing for the initial uh, application, you have to be like as a it should be a like entire whole package. The legal terms and what you are trying to cover should be very clear. And there are like unique features in Indian system. Like there is a section called like Bolar exceptions. The section 107A aligns, which allows the generic to start trial before the patent expires. So this is like very important thing. That's why like the healthcare is like very affordable in India than the other countries. So this is like very good thing about the Indian government, like they allow the generic before the trial expires. That's that's the reason like Indian generic industry has like running really hands in hand. And the other countries like US and EMEA, where the date exclusive protection is like very solid, it can go up to 12 years in biologicals. So even though the people has developed and provided the high-end technology to the world, the affordability is the point where it is limiting to like all the people get the maximum benefit out of it. It shows like only whoever can afford, they can able to get the medical system easily. So it's always like that's a very good uh, thing about Indian medical system. That's why like generic debt is like more often in Indian market, and the affordability will be like very easy for the people to get the treatment. So that's why like people from other countries also traveling to India like to access the system. It not only because of the cost effective system, but most of the medications what we see as a global competitor, we see like very less side effects also from the drugs from Indian market, because the regulations that is provided by the Indian government is very strict and very straightforward. So the other other regions are not like very straightforward. The Japanese are like very stringent with their permissions and approvals, but other nations are like, not like that. So like from our own experience in oncology and neuroscience, we have seen like how aligning patent claims closely with your labeling, and that creates the stronger IP protection and smoother regulatory approval. So like why I'm keep on telling like keeping up the terms and keeping the laws, everything in mind, then you have to find a entire like whole package of application without any pitfall or loopholes. So that will take like very closer to your approval easily. And another thing I want to touch is like the AI revolution in human healthcare. Now the AI is growing really faster. that too in healthcare industry, we have to wait and see how it's complementing to the discovery or it giving any potential pitfall. So far what we have seen is like a very good like productive data from AI side, but we have to wait and see in coming years how it can able to like help the innovation. So like the AI in its own dimension, when we think about the alignment, like let us not forget the biggest disrupts in our like field. So we see like when we generate data with AI, like whether these kind of like LM is bringing all the original datas like that aligns well, and whether the understanding of these machines are really good, or like whether it really thinks like human, that's a like $1 million question. Like in a recent discovery, the AlphaFold, a software that has already predicted the structures of over 200 million proteins. So like to predict this 200 million proteins, like it's going to take years and years. So with the help of AI, we could able to do it within a very shorter period of time. So we have to wait and see these kind of support from AI is going to be like positive, or it's going to have some gap between the actual invention of how the machine generated data goes hands in hand. So the AI for drug repurposing, it also like the new COVID-19 treatments also like enhancing with this AI technology. We also like need to wait and see how the mRNA technology is going to evolve more without any side effects with the use of AI technology. And uh, we see the AI also really helpful in clinical trial. So usually like before, like to get the perfect matching for the trial is a really hard job. So we have to connect with the multiple locations to get the patients, and the records availability are very much limited. With this AI, like integrated system with in between the hospitals and within the hospital group, the matching patients is really fast. So it's cutting down the recruitment delays. So sometimes the drugs are already ready for the testing, but because of patients availability, it will take like more time, and the results will be delayed, and like to reach the actual public, it may take like years and years. So with this AI and enhanced like enhanced way of finding like people for trial is a very good thing to support the clinical trial. So when it with AI, like how in India, like the AI is used. So in Karnataka, the AI powered screening for diabetic retinopathy is already in trial. We have to wait and see like how it goes. And the AI tools also being deployed in low cost TB diagnostics, and making screening faster and cheaper. So this, like, as I said earlier, we have to wait and see like how it's going to help in the innovation and making the life more easier. And I want to give like what will be the possible you can do like with this AI technology. If you want to target a kinase in 48 hours, the AlphaFold generate models, and you can dock compound virtually, and you can able to filter 5 promising leads and file the provisional patent. So it's going to take a week time for you to go for a provisional patent. These AI technologies are like very faster, and these like they are not just speeding up the research, it also accelerate the entire innovation pipeline. And we have to wait and see like how it's going to complement the research. And with AI and IP, there is a great debate like who owns the discovery, whether AI going to own the discovery or the humans are going to own the discovery. There are like lot of debates going on, and the courts in US, UK, and European Union, they have ruled out that AI cannot be listed as an inventor, even though if you have a tool that you cannot able to patent the tool. So only like you cannot include those tool as a inventor. So you can own patent for the tool, but you cannot include those tool as an inventor. So they told like only humans can be the part of inventor, and India also like they have told like they are going to follow the same principle as like UK and European Union. So let us ask some question like when if an algorithm generates a novel drug scaffold and you are going to validate it, and who get inventorship? Whether the humans are going to get the inventorship, the AI, or both of you are going to get. So there are like other challenges out for with this AI technology. The AI outputs are just like obvious combinations, or it's going to be genuine invention. So like I said, like we have to wait. All these predictions are whether it's going to be the novel or the algorithms are just bringing it. So even though you like able to dock those proteins, when you actually like bring out and you have to analyze that, then only you come to know, oh, like the prediction is correct. And when you train the AI model, who owns the training data? That's also fuels the AI model. And so the regulatory requirements should be more harder in the part of AI when it is used in trial design, like trial clinical trial. That's also like $1 million question. So these AIs are trying to find the perfect match for clinical trial, but it is the starting phase. So we have to wait and see whether we are getting the actual benefit from AI. So like these are like no longer hypothetical. It was now a debate we must engage in. Should India stick with the human-only intervention rule or prepare for future where AI itself might be recognized as an inventor? So like everything in the hands of science, how it's going to evolve. And let us see like how India is going to be in the innovation in future. So like and where will India lead in the coming decades? Let us look into it like at different parts. In digital health, from software as a medical device to telemedical platform, India is a unique position to scale low cost and high impact solutions. When it comes to cost, always the India comes first in like providing a very cost effective and like very sophisticated treatment to people. And the personalized medicine also like it's blooming with the cancer biomarker invention, and genetic diagnostics are moving as closely to truly individualized care. So this is going to help people to get the individualized care without any side effects. The major problem is the quality of life after the treatment is a big question mark when it comes to oncology. So with these personalized therapies, people can able to lead better life after treatment. That should be the major major goal or the principle as a researcher or as a company. When we produce something, people will be benefit out of it, and what will be the life after treatment. That is the very important question that we need to keep in mind before bringing up any product to market. So with this, the personalized medications, one day like world can able to get better like healthcare system with like better quality life after treatment. And the cell and gene based therapy with a NextCare 19, and also like the NextCare treatment from USA and China, they are like just beginning. We are entering an era where India won't just copycat global breakthroughs. India can able to create its own like therapeutic lead in the world. And molecular farming also, like it's a rising industry in India. Like imagine like a biological products, the plant based, and these kind of plant based products can able to bring down the cost dramatically. The very good example is like our EPO, the commercial EPO. A single dosage is going to cost people like $20,000 to $30,000. And the commercially produced EPO, so we are producing from tobacco leaves. So like our downstream process also very straightforward without any interference, and because of that also we don't see any potential side effect. So these kind of plant produced and biotechnology innovations can be bring down the cost and also reduce the potential side effects. And another important thing is like blending traditional and modern sciences. The Ayurvedic formula strengthens up like robots, like it's growing like anything. In future a time period, it's not just like the traditional medicine like what they are following. Like now, like we see like many labs in India working how scientifically they can able to prove these Ayurveda formulations, and try to tell the world that this is not just like a traditional or like a formulation without any base. We are trying to establish like our traditional medicine also like very scientific, and it can be like very effective in treatment without like very less side effect. As a neuroscientist, what we see is like all the medicine what we have in market is potentially they are only bringing down your symptoms. So there is no strengthening medication or like proper cure for any protein coagulation and like protein deposits. So we see only the medicines that is available to take care of your symptoms, not the actual cure. So the Ayurveda system, Ayurveda system can able to strengthen up the muscles, and it can able to provide better support to the peoples. So I hope the scientific like the scientific formulation behind the Ayurveda has to come out like very faster, so that people can able to accommodate these kind of formulation in the modern medicines, so which can enhance the target specific delivery and also enhance the treatment better. And with the funding opportunities, like the good news is like now the funding is abundant from DBT, DST, CSIR, and BARC. The question is whether our researchers are like simply publishing papers, or they are protecting and they are translating their idea into an impactful products. So that's in the hands of budding researchers and the budding like biotechnology or like pharmaceutical companies. the real test is like the future of Indian healthcare. Invention will not be decided in journals alone. It will be decided by how effectively we move forward ideas through the IP pipelines and deliver them to the patients. And so now, I want to open the forum for discussion. Like I have three main questions. If AI suggested new drugs and a person validates it, who do you think is going to be the inventor? Should India keep an eye open for different model drug datas, or it has to stick with the extensive like the 12-year protection like United States and other unions? So what will be your opinion? Whether like a generic drug that is available in market is like very good, or what do you think in going forward the long-term protection will be giving benefit to the company or the inventors? And the third section is like section 3D, like whether these particular by government like blocks your new invention and things like what is next. And is the present patent process a novel formulation or device-based delivery methods will be more beneficial, and what is your opinion on that one? And thank you. This is all about the session. And if you have any questions, like you're good to ask. I'm happy to answer.
Any questions from the participant side?
No, ma'am.
Dr. Maitri, there is one question in the chat box.
Yeah, I see. Yes. See. So I see like Dr. Bindu, she has answered, even if AI generates the idea, the human researchers are here to validate, interpret, and applies. It would be considered as a like inventor. So like it's a good point, but we have to wait and see like how these models are going to play a role in future. So like as a neuroscientist, like I need to raise a question, like if it goes like that, whether people are going to study the concept like from the beginning, whether they are going to dig more deeper into the like debating with themselves, or they are just going to blindly believe what the data generated by AI is correct. There is like there is a niche between like how people are going to take that in future. I know like it varies between people, but we have to wait and see. Like it's both the side, like how it gonna make it. And do you have any question like what kind of work we do in our lab, or like any information that you need
Yes,
from
just
regulatory side?
yeah, brief overview of that. If you would explain, that would be nice for the participants.
like we are Jiahuazi's lab in Bright Biomanufacturing Research Institute. Like we run a NIH project. We have multiple neuroscience project going in our lab. Like I work as a biotech scientist for those project. I do like make clones and construct for the project. So we have two main projects that we have in our lab. One is like the EPO project. We are trying EPO medicine for the stroke models, and these EPO protein gives like 98% coverage for stroke when it is injected within 24 hours without any hemorrhage. And the very big challenge that we are facing is like the chlorophyll interference when we are like purifying the protein, that we are trying to like like figure out with this alternate chlorophyll biosynthesis pathway, heme pathway. So we are trying to alter a couple of genes in the pathway and trying to produce the protein with heme pathway. So with heme pathway downstream, it's not going to convert into chlorophyll A and B. Before that, like it's going to be like as a CHLI like gene, where we are going to modify that and we can able to like produce the protein by bypassing like conversion of the heme into chlorophyll A and B. That's like a very big projects that's going in our lab. And we are also creating a plant neuroscience model. So already our lab, we have created like a neuroscience, like plant neuroscience model for Huntington disease. And we have published that, and like we are patenting that one as well. So we have produced Huntington plant model, where we are seeing the polyQ expression makes huge difference in plant behavior. So the root behaves like a human brain, and we are seeing like the chloroplast is like underdeveloped, and other systems are underdeveloped. And we are also seeing protein aggregation in the leaves. When the polyQ is like extend more than 35, we see like based on like increased expression more than 35, we see like 64, we see more like aggregation, and with like more than 100, we see a lot of accumulation. So these kind of protein accumulation is seen in people with Huntington disease. So with a Huntington gene that is expressed in tobacco plant, we also see the same kind of behavioral in the plant like human. The root hair is not growing properly. So because of root hair is not growing properly, the plant is not getting enough signals to make the proteins and photosynthesis. And we also see like aggregation in the plant like leaf tissues. So with this, like we can able to figure out how BH4 biosynthesis pathway can able to study in detail, because like we are trying to find how the folate mechanism can able to like able to contribute to the disease progression. So in plants, we have found out this folate mechanism help the plant to resolve somehow from the disease. So like the human, we need like a folate from the external source. Plant can able to produce its own folate. So like initially the healthy plants can able to like produce more folate, and these folates can able to delay the polyQ expressions. So we have found out the folate mechanism downstream help us like to regulate the BH4 biosynthesis pathway, so that plant can able to produce more folate protein, which helps in clearing those aggregations. So we are trying to do folate therapy with the like pregnant pups, like with the Huntington model. So we are seeing like more progress, like delaying of diseases. So the actual Huntington carrier, they can able to develop the cognitive disabilities from age of 30 to 65 based on how many polycues are expressed. With this folate therapy, we are seeing delay in the progression of the diseases. And we are also intensively studying BH4 along with THFR and GDP-CH, how this folate also help in epigenetic modification when it is when it is altered. So these are the like main projects that going in our lab.
Thank
So
you,
in
Doctor.
future, like
Yes.
sorry, like
Yes,
in
you can
future
continue.
in future we are trying to develop Alzheimer models also. So hopefully that can give more factors beyond amyloid protein. So we are expecting that in future.
There is one question in the chat box.
Yeah, like the commercial produced EPO, it stays in the system for 24 hours. That's why like this can able to produce more like red blood cells. So it causes tissue damages and hemorrhage as well. So our plant produced EPO without like sialic acid, it stays only in the system for 2 minutes. When it is taken within 24 hours of a stroke, we see like 98% complete blockage removal, like dissociation, and we don't see any hemorrhagic side effects. So, and we could see the tissue protection even when we check mouse like 72 weeks. So like we are expecting when we go for trial, that should be efficient even people between 60 to 80-year-old.
Is there any other question from the participant side?
And also the production cost is also like 100 times less than the commercial EPO. Yeah, can AI predict the amyloid plaque formation? These amyloid plaque formations, like definitely AI can able to speed up the process. They can it can able to predict like uh, uh, like uh, in the plaque formation, other than proteins, what are all the other molecules that can be found in the plaque. So this will really help people to understand how to make some product that can able to prevent the plaque formation, and also able to like how we can able to clear the like already formed like molecules. So definitely AI can able to speed up the process.
Thank you, Maithili, for the nice and informative session. So I think all the participants got benefited out of your topic. And there is a feedback link that is posted in the chat box. So participants, kindly fill in the feedback link, and it will also be posted in your WhatsApp. And we request you to fill it as soon as possible because it will close at 9:15 to 9:30. So, and tomorrow there is a session at 6 p.m. and I request all the participants to be present at 6 p.m. tomorrow. Thank you.
so
Thank
much.
you, Dr.
Yeah, thank you.